but race plays such an important part throughout that system. And if you ignore race, if you don't make it the primary place to start your conversation, you're really um, doing injury to what the reality is that people face once they're brought into the system itself. So, and I don't want to overlook other factors. I mean, clearly, if a person has wealth versus a person who comes from poverty, class is going to play a very big role. Gender and sexual orientation in certain situations will, religion will. Um, and there's so many places where, we can look for other explanations depending upon the circumstances. But we never really want to forget that slavery was the law of this country, of this land, for 240 years, 8 generations of people, you know, experienced, suffered the institution of slavery. And that's the piece where I think it becomes difficult sometimes to talk about race and slavery in a way of understanding what's happening in today's current system. But when we really appreciate the fact that the laws of our land, the Supreme Court, legitimize and constitutionalize the institution of slavery. When all of the customs and practices were based upon, the idea that of white supremacy, of black inferiority, those are the conversations that are much less frequent. And then I guess when you look today, I teach a course over at the law school. I teach a race and criminal justice course. And I had something similar when I went to law school. So my students get a lot that if I was teaching in Florida, I would be in a lot of trouble. I probably would have lost my job. I might have been criminally prosecuted. My friends from different law schools in Florida are doing everything they can to get to another law school, another state, like Maryland, which is a safe state. But it's the idea that when states are passing laws that prohibit their teachers from educating them about the history of slavery and how it plays out today, we leave our young people without the information that they need to make sense of things. So it's the idea that when I talk about slavery, I'm not just talking about the actual, chains around people or forced labor. I'm also talking about the modern day vestiges of the institution. I'm talking in the law, we call that the badges and incidents of slavery. And that's how the Supreme Court would decide things. The badges and incidents are what would prop up, what would reinforce the concept of Blacks' inferiority. And then, whenever the discussion turns to something like reparations, like compensation for the generations that came after and what their ancestors suffered and how the families were destroyed, how the children were taken away from. Whenever we have a Ta-Nehisi Coates that's going to remind us about reparations, or we have, a Brian Stevenson, or we have a Bell Hooks, or we have a Fannie Lou Hamer, or we have a Congressman John Conyers, who every year would come up with a reparations bill. And then, God forbid, we should have a law professor who actually brings this stuff up in the classes. You know, this is where we constantly hear, you know, the refrain or the denial that's coming from the white community. It's like, we weren't there, we didn't do it, we're innocent, you know. It's the idea that slavery's a long time ago. Like, get over it by now, you know, just move on with your lives, you know. And that's usually the defensive sounds that we get when we want to bring up a question as serious as reparations, you know, and the justification for compensating people and their ancestors for what this government and what the people of this country, you know, reinforced. But I know that I'm supposed to be talking about criminal justice, and for some of,
can I ask one question?
sure,
Am I also correct that the US government has never apologized for slavery?
you're correct.
Yeah.
You're correct.
Yeah.
I mean, even something as simple as an apology.
Yeah, well, it's not so simple.
Well, but
Right.
yeah,
But yes, no, there's never been an apology. There has been a get on with your life kind of
Right,
thing.
right.
Stop bringing up slavery or race or whatever. But the idea here is, when we talk about criminal justice, for many of you, the idea of reparations and criminal justice actually goes hand in hand. Like, you really can look at the criminal justice system to understand why reparations is required. But what I want to do in talking about the topic of criminal justice is, I want to introduce you to, you know, to the Supreme Court that sat in 1857 when the Dred Scott versus Sanford case was decided. You know, many of you have heard of Dred Scott, but you probably don't know the story. So I'm not going to tell you. I am going to tell you that I teach this in class. It's a 240-page Supreme Court opinion. I give an excerpted 20-page, which I have brought with me here because I have a couple of quotes that I want to refer to. And you know, and the chief judge, the chief justice of that 1857 Supreme Court was Maryland's own Roger Taney. You know, and you had 7 justices who signed on to that opinion. And when I talk about, you know, how that decision upheld the rights of slave owners to do what they had been doing, not just against the enslaved Black population, but against the free Blacks as well. So the Dred Scott opinion took into account every person of African ancestry. Whether you had been free for 100 years, you were still going to be lumped together with a racially inferior group of people. And you know, the phrase that most people might be familiar with is that, and I'm paraphrasing, is that, you know, Blacks had no rights that a white person was bound to respect. The actual language from the court, and they're describing why African people were not considered, you know, certainly not considered to be equal to the white person, but as the court said, they were at that time considered as a subordinate. Oh, I should paraphrase. I always tell my students this: the language in Dred Scott is blunt and it's painful, but it's the truth, and it captures those 240 years. So I prepare my students, because for my students of color who are going to be reading this, many of them are going to be affected the way the Jewish community is affected from October, you know, 7th. Yes.
I'm curious, your course that you teach in college.
No, law school.
Law school.
Yeah.
Excuse me. Is it a required course? Is it an elective?
It's an
And who
elective.
takes it?
It's an elective.
And who takes it?
The people who want to learn about race and criminal justice, the people who are going to become prosecutors and defense lawyers, the people who understand.
What's the racial difference? More black, more white,
Every
Hispanic?
year it's different.
Every
This
year's
year,
different.
I'd say it's half and half. Last year, I'd say it was 1/4 black and 3/4 white. So I get plenty of white suits, if that's, it's
No, I
not.
was curious, yeah.
And it's also understand that as a white person teaching this course,
Uh-huh.
I had to prove myself the same way I had to prove myself when I was a lawyer.
I bet
And
you did,
and the
yeah.
white guy comes in to represent the black defendant. And New Yorkers are not like Baltimore people. Here, people know how to be civil. They don't tell you what they're really thinking. They'll smile at you and yes you on. New Yorkers don't do that. I would go back there when I first started and I call out, Jim Smith, and he'd say, "Hey, I don't want you, Whitey. I want a black boy. You're the one that put me in here." And I would say, "Well, look, let me represent you today. If you don't like my representation, I will do everything in my power to get you a black lawyer." And the highest compliment I think I ever got was after making my argument and losing, not getting the person out of jail. Jim Smith would go back, first words to everybody in the jail cell is, "That brother's good." He fought that judge, and you guys should get him. Now that's the highest endorsement you can get.
Yeah.
When you're a public, they call them legal aid lawyers in New York, but it's the same thing, when I'm teaching my class, the students are very polite. But in the very beginning, it's kind of like, you got to prove yourself. You got to prove you know something, that you're not just one of those white liberals that are going to come in here and start telling us, things that we already know. I was fortunate. I had this course taught by one of the great white civil rights lawyers of our time, but people don't know Arthur Kanoy. But Arthur was partners with Bill Kunstler, who you might have heard of. And so Arthur gave us so much. And many of my classmates are still practicing. They're still fighting the good fight. But the idea here is when the Supreme Court is talking to the American people, and I won't give you the whole history background, you can ask about it in the Q&A, but this is a time where the whole nation is so divided, where there's abolitionists against white supremacists, where you're having armed warfare between John Brown abolitionists and white, and literally people are being killed. And so the Supreme Court, President Buchanan said to the nation, "Look, folks, in a very short time, the Supreme Court's going to decide this issue. So whatever they decide, go along with it," because I'll tell you a side story later about President Buchanan. So he has to explain to the American people why the black population are not regarded as citizens of the United States, as we the people of the United States. And pretty early on, he says, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. This is the Supreme Court, right? So I always call this document the Supreme Court opinion. This is as close to a white supremacist document as you will find in legal circles. This is white supremacy through and through. And when you speak about the justification for the institution of slavery, the Constitution, remember, we're talking about rights of people. We're talking about, rights of liberty, rights of property, rights of due process. And because the court has to justify or rationalize the whole idea of enslaving this entire group, around this time there were 4 million enslaved blacks. So the justification that the court is going to give is based on blacks' presumed racial inferiority, but it's not a presumption. The court calls it an axiom. And you remember your days from trigonometry, probably, when they always said A squared plus B squared equals C squared. You don't question that formula. You just apply the numbers. So here's what Justice Taney's majority opinion, how he's reviewing history and why blacks are not regarded as people or citizens. They had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit, for the black person's benefit. He was bought and sold and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. And here's the sentence. It was regarded as an axiom in morals as well as in politics. So, when you think, because sometimes when we're having our class discussion, I'll say, so how did they ever prove black inferiority? And they never had to.
It's not like trigonometry.
Right.
Yeah.
It's an axiom. You don't question it. Of course, lots of people were questioning it. There was an abolitionist movement for 25 years. William Lloyd Garrison was publishing The Liberator. So it's not like the country didn't have, they never viewed blacks as equal to whites, but they viewed them as people entitled to the same rights in our system. So when I say all this is all the background, and I know I have a limited time here. Fortunately, my classes go for 3 hours, so they put up with me for a long time. But interesting, there's never been a student who's fallen asleep or even playing on the computers or anything like that. I mean, they're kind of stunned, I think, by all this and the fact that it's being taught in a law school class. But after this decision in 1857, it was meant, by Taney and the Supreme Court to put off a civil war. It was the idea was, if the judiciary protects the slave owners' rights at the expense of Dred Scott. See, Dred Scott sued on behalf of his wife, Harriet Robinson, and their 2 daughters, Lizzie and Elizabeth, because only the man had rights. So everything, but it wasn't, as I said earlier, it wasn't just their rights. It was the entire class of people of African ancestry, people who had been kidnapped and forcibly brought over, from their homeland in Africa. So Taney's thinking was, well, we have a president, a Buchanan, who's a pro-slavery guy. We have a Congress, which had, with all those, southern states, majority there, they rule the legislature. And now they have the judiciary saying slavery is constitutional. So that surely should put off the war, but it didn't. many historians don't call it a civil war. They call it a war for Southern independence. And that's really what it was. It was the South wanted their own nation state. That's why they seceded from the Union, because they wanted to have a state with slavery. But that's not what happened. And you know that the Union Army defeated, the Confederacy, but maybe what you didn't quite put together is that the turning point in that war came during its third year, when right after Lincoln's Emancipation Proclamation, that's when 200,000 freed Black men joined the Union Army. And you saw that from the movie Glory. It's a fabulous movie. And it's got so many Morgan Freeman. I mean, it's got such a cast of people. So there's two movies I'm going to recommend to you. One is Glory, and the other one is what's coming up here called the 13th, and because the war led to the abolition of slavery through the 13th Amendment, and the way the Confederate States responded to that, and Eric Foner does an amazing job of capturing this history, is that first year, 1865, first 6 months, really, after, not even 6 months, well, wait, 13th was in January 31st of 1865. So
65, 63.
65. So then the next 9 months or so, when the 13th is getting ratified, and Lincoln had to twist arms to get the 13th ratified. And after it becomes law, that's when the Confederate States reacted by just massive killings and massive violence. And you can read almost every state. Texas had 500 people that were killed, and they had people who were on trial because the federal government had taken over at that point. And not a single person was convicted because you had all white juries. And those are the only people who could serve. So I'm leading up to the fact that when Congress came back from their break, in December, and they saw the way that the Confederate States had reacted to the 13th, they decided we got a lot to do here to teach those folks that we are in charge of this country, not the legislators of the individual states. So they passed several civil rights. Altogether, they passed 7 during the Reconstruction period. But they passed the 1866 Act. And the reason I want to bring it into this short overview is that it's still law. And it was a law that specifically identified the rights that had been denied to the enslaved people. And so it had in there that the federal government was going to protect your right to enter a contract, a working contract, to buy property. All of these things were the badges of slavery. You didn't have any legal status, so you could not enter. Access to the courts, the right to testify against a white person, again, badge and innocent, and the equal protection of the laws. And the last words are the most important: the same rights as white citizens have. You don't see that in a statute. You don't see race that explicit. But that's exactly what the 39th Congress meant, like to spell it out. If you guys continue denying and killing, we are going to allow people to transfer their cases, remove their cases from the state court to the federal court. And the federal court is for the first time where Black people serve with white people on multiracial juries, which really explains why the Department of Justice and the civil rights department, which was formed right there in 1868, had an amazingly successful record of convicting and incarcerating white supremacists. As you know, Amos Ackerman, I never checked his religion, but he sounds Jewish to me. And Benjamin Bristow. Bristow was the Attorney General, and I'm sorry, Amos Ackerman was the Attorney General, and Bristow was one of their best trial lawyers, and he did the first cases. And they went to these cabinet meetings, and they would be talking about their successes. And finally, one exasperated congressperson just said, "Could we get on to something else? You've got the Klan on your brain. You keep talking about putting them out of business. Let's go on to some." And the response was, "It should be on everyone's brain, you know, because for the first time, white supremacists were brought to justice. Before that, they could do whatever they wanted with impunity." So I mention all this to you because when you look at today's issues, everything that you can look at is tied to Black inferiority. You know, when you keep someone in jail when they're presumed innocent at the bail hearing, and you let the white person or most white people go home, you know, it's like you're not treating the Black person as a whole human being who's entitled to their freedom. But then when you think about the people who are incarcerated, the people who are arrested and charged with crimes and sentenced to jail, you know, you've got a 70% prison population of Black and brown people. 70%. It doesn't mean that white people aren't committing the same crimes. You know, you take drugs, for instance. When they passed those crack laws, you know, in the late 1980s, they made crack 100-to-1 ratio to white folks, which meant 5 grams of powder cocaine. I'm sorry, 5 grams of crack cocaine mandated a 5-year minimum prison sentence. It could be your first arrest, could be your first conviction. 5 grams is like 1/5 of an ounce. If you were the white CEO that was partying and enjoying your powdered cocaine, you had to have 500 grams in order to get the mandatory 5 years. What that meant, if I was representing the CEO, I would go into federal court and say, "Oh my God, I don't want that mandatory sentence for my guy. I want to get this case transferred to the state courts." And the federal prosecutor and the judge was only too happy to accommodate me. So my white rich clients would get drug treatment. My poor Black, the only people they prosecuted in federal court in those years were Black defendants. So it's almost like you can go through, you know, everything we see today, people walking the streets, Black people walking the streets and getting stopped and interrogated and searched, patted down. Black people driving their cars on 95 and getting stopped and again going through that doesn't happen to hardly any of the white folks who are doing the same activity. It's called walking while Black, it's called driving while Black. And, you know, it's the idea that people, when they're eliminated from jury duty on the peremptory challenge, which means you can strike anyone you want, they have certain limitations now, but there's ways of getting around it for a party that wants to get rid of Blacks on a jury. You know, they want the jury to be as white as possible in interracial cases, you know, Black on white, or police cases. If a police is ever a defendant, if I'm the lawyer for a police officer, I want the whitest jury possible, because they understand police are there to protect them, and they're not gonna hurt that officer. So you can go through, obviously this is not criminal, but the whole disenfranchisement of so many black voters because they have a criminal record or a criminal conviction. The idea that the sentences that black defendants get, I can't tell you the difference between a sentence today and 50 years ago when I started practicing. It's like they throw out life without parole like it's nothing. Life without parole means in Maryland, now it's down to 10 or 12-year-olds. So you get a 10-year-old committing a murder, a serious crime like that person literally can be, and in other states is, sentenced to life without, you're gonna die in prison. You're not getting out ever. Or it could be the 40 or 50-year prison sentence. And then of course the people who are on death row. It's not gonna happen to white folks who kill and murder. It's gonna be rare. I shouldn't say it can happen. It's gonna be really rare to have a white person executed. And so it's the idea that race plays such a pivotal role at every single stage. And you guys can ask any of those questions, but I just want to conclude by saying that, and this has been said before, I know Ricky was saying it and other people, we have such a long ways to go to ever consider our legal system to be just and fair. That's why, many of us, I refer to it as the criminal legal system. I don't say the criminal justice system, and the idea here is that, momentarily we've lived through periods where the white community has actually stood with the black and brown community. When George Floyd was murdered, when everybody saw that, momentarily it looked like it had many other times, like there was really going to be change. And what the system does is it waits out the protests. It waits until people get fed up with the traffic stoppings and, whatever property damage is taking place. And from that point on, people forget that you saw George Floyd murdered, strangled to death, choked to death. But there are so many George Floyds that you never see that, I remember something just popped into my head, which may not at all be relevant, but there's always music that I'm thinking of in songs. And there was a song by Gil Scott-Heron, and the revolution must be televised.
Yep.
So
Play it all the time.
it's it's the idea that even when people see what happened, on January 6th, they're being told a whole different story, and they forget what they saw. So, it's so important, and Colbert has done some of this, but it's so important for white folks and religious communities and to really, reach out and join with communities of color, because as bad as we think, things are right now, and I know, I forget who it was who was saying that, maybe, forget who it was, but who was saying that one of their friends is paralyzed right now with fear. We are so fortunate to be in this country with our status, with our, material wealth, or, it's not to say that some people aren't hurting. I don't mean to suggest that, but when you look at the other populations, what you're left with, and many people echo this today, is, yeah, you have to take care of yourself, but that allows you to help take care of other people as well. And final thought is we must remove for once and for all this blot of race that has been in our system for 400 years and that always has a way, of reinventing ourselves. And we have to value a Black person's freedom and right to live as much as we would value the people in our family or in our community of friends. So I leave you with that and open it up for any comments or questions.
Um, over the past 50, 60 years, has there been a change in the judges' attitudes at all?
No, judges are products of the very same system I'm describing, and most of the judges, the majority of judges come from having formerly been prosecutors. And they're prosecutors, the ethical code says a prosecutor is a minister of justice. That is not the way almost every office operates. They consider justice to be when we put someone away in prison. They don't consider justice when we don't prosecute someone, not merely because we believe they're innocent, but also because it's not in the interest of justice to prosecute everyone. So, when we look at judges, with very few exceptions, overwhelmingly, most of the judges, I don't want my client appearing before. They're going to hurt my client. They don't have, forget about compassion. They see things really in the starkest terms. So we are really taught that our system is the best and the fairest and the most humane. You guys haven't been to court. I'll bet you haven't been to court in a while. I'll bet you haven't visited the jails or the prisons. I'll bet you don't look at everybody we think is in jail. We think, oh, they're really dangerous, because that's all the TV news tells us. Everybody shooting or getting killed, even today, even though that's all a low number, relatively low. We don't hear the other stories of the people. They were prosecuting marijuana up until, I think, 2 years ago. And the people that were being prosecuted, my clients, were young, Black, and poor. They were smoking. They were using. They were getting 90-day sentences, 6-month sentences. The white kids are doing the same damn thing. But that you can't make that argument to a judge without the temperatures rising. I can do it, but I have to really tread carefully. Are you calling me a racist, counselor?
Yes, I am.
No, Your Honor, I'm merely pointing out my observations of what I see. I've had clients before, different courts, white clients, who don't get jail sentences for possession of marijuana. But my clients of color, my African-American clients, they seem to always wind up getting jail as if 90 days is not a long sentence.
Quarter of a year.
I mean, for anyone here, 1 day, 1 hour in a jail cell, in a cage, and you be making your appointments with your therapist as quickly as possible.
The other thing is the jails, right? I mean,
Yeah.
and we have so many jails for profit now, right?
Yeah.
Where and then, there are countries that actually have, I'm going to call them successful jails, where they actually have education and training, and the goal is to get people back out into society with the skills they need in order to make a living.
But not the ones for
And
profit.
we don't have those jails anywhere in the United States. And I think it all goes back to not only the time of slavery, but then Jim Crow, because the jails were a really good way to control people. And it is an industry that makes huge amounts of money. So it's all about greed. And the majority of people in the cells are of color. I mean, there are certainly, whites there and what have you, but, the majority are people of color, and it is a horrendous place to be and very difficult for anyone, including in the juvenile system, to get the skills they need in order to not end up back.
See, again, it's the idea that teaching a Black person, an enslaved Black person, to read and write, that was a felony crime in Connecticut until 1837. In Connecticut, one of the states that had abolished slavery.
Well, it wasn't only a crime, so I did
Yeah.
some of my growing up in Jacksonville, Florida, and we moved because my father was teaching, he worked in a factory, and he was teaching the Black men who were janitors to read and write, and we started getting crosses burned on our lawn, and my father was targeted, and he finally said, I'm willing to put myself at risk, but not my whole family, so, which is why we moved.
So Ricky, what year was that?
That was
approximately?
1956,
Yeah.
Okay.
No, I mean,
56, 57.
there's so
Not
much
so
that
long ago.
repeats itself, but it comes in a different form. That's why whenever I hear people say, well, things are so much better now. And if you ever heard yourself saying it, please stop yourself. Like, don't say that, because you don't know the lives of other people. That's one of the things that came out of the morning's talk is we have to learn about other people. We have to learn about their lives before we can start preaching to them. Oh, you voted for Trump? Oh my God. You know, it's like that is such a liberal perspective where you're putting yourself as you know better than they do.
Right.
You know, and the idea here is the one thing I'll slightly disagree with you, Ricky. The best part of most prisons and jails is that they do have public school education there. And many of the teachers are really dedicated. I mean, my clients will the ones who, you know, really want to make something of themselves, they will say, I don't want to miss my class. You know, and that's why they got rid of the Pell Grants, where you could actually get a college degree while you were serving felony time for serious crimes. And once you start humanizing people and see them as people, it's what Brian Stevenson's always said. No one is the worst person.
No one can be defined by the worst thing they've ever done.
Thank you.
That's what he said.
Thank you. Right.
Yep.
Yeah.
Yeah, he's a great
To
speaker.
me, it's a little bit even more frustrating, in that it's not just white people who are racist.
Yeah.
And it's subtle. I served on 2 juries in Baltimore. Both the defendants were African American.
Thank you, Steve, for doing. No, thank you.
In one case, 11 of the jurists voted that the defendant
was guilty.
Not guilty.
Not guilty.
Not guilty.
And the lone holdout
But the
was.
lone holdout was an African American.
Yeah, yeah.
He's guilty, and he insisted that he was guilty until the woman next to her said, "Of what?"
Right.
And when she asked that question, it was, "I don't know. I just know that he's guilty."
Exactly.
Right?
Exactly.
And at that point, she was able to flip. A second jury, 11 people on the jury. It was a mixed race,
Right.
Baltimore jury, so it was a mixed
Right,
race jury.
right.
Actually, I was in the minority.
Right.
11 people insisted that the defendant was guilty. It was a drug case. It was a serious drug case because he had a gun. Which means that the penalty is severe. I don't remember how many years.
It's
but
an
it was-
extra 5 years.
It
for
was
that.
severe.
Yeah.
11 jurists insisted that he was guilty, and I was.
You were the lone
I was the
holdout.
lone holdout. And
That must have been a very unpleasant experience.
it was not my
No,
best day.
no.
But
no.
the thing that bothered was he had drug related paraphernalia
Mhm.
in the trunk of his car.
Yeah.
And everyone but me insisted that that paraphernalia was for the purpose of distribution,
A distribution.
as opposed to the
Use.
purpose for use.
Mm-hmm. Yeah. Yeah.
And all of the African-American jurors insisted, why would you have that for use?
Right.
Right? When you can make X amount of dollars selling.
Yeah.
And I'm sitting there going, but you're making, it's a presumption
Yeah. Mhm.
without evidence.
I would have loved to have been the fly on the wall.
It was horrific. And what made it even worse was it was 4 o'clock on Friday afternoon.
So how did it turn out? Okay.
Yeah.
You cave?
I caved. I didn't have.
You have to have 3 people in the dissent during deliberations to hold out.
Yeah,
It's nasty as hell.
I
They are
The
calling
pressure,
you
the pressure.
everything. Forget racial stuff. They're calling you stupid and everything else, and really at times screaming at you. I want to go home. You know.
I didn't
I
have.
was part of that.
I didn't
I had
have
the same
evidence other than to
situation.
say, other than to say, innocent until proven,
Unless,
right?
unless, until is an assumption that he will eventually be.
Okay,
It's
until- but-
unless.
You know, there was no ability for me to raise the reasonable doubt.
You know, Stephen, one of the things I was just saying, when you're a member of a poor or low income Black community, you are not getting the police protection
Right.
that you get where we live.
Yeah.
And you basically get the attitude that nobody gives a hoot about us. And so when the drug dealers, the kingpins, when they're destroying the community, when the kids are hooked and nobody cares about them, there are members of your jury who are saying they can't have any
I get it.
compassion for it. We're not getting this kid off on a technicality.
Yeah.
You know, this kid and people who look just like him, they ruined, they killed, they hurt,
But
and
that's a racist.
it is, except it's a more understandable way
I get it.
of dealing,
Because
and
it's a lived reality.
yeah,
It's a lived reality, and at the same time, when you take that lived reality and apply it to an individual who is probably only there because he's African American. I mean, if I were to tell you the whole story of the arrest, you would go insane. I'm not going to go there, but is the kind of thing like if it were 2 white guys that were on the street, it
Yeah.
never would have happened.
and Black folks basically, you know, are going to be lots of lawyers want to pick any Black juror to be on a jury, and it's such a big mistake, because if anyone's going to convict and cares about making their community safer, it's the Black people who live there. And that doesn't get politics involved. It's the idea that nobody else is doing anything for us. I have a chance to do something now.
I just wanted to raise
Yeah, no, I think
that, that the complexity of
Oh, yeah.
racism
Well, that's the
goes
thing.
way beyond.
You can't just pick by color. You know, there's so many good white people out there, you know, who frankly, I hope all of you get to serve on juries, because you will make sure that the verdict is going to be based on evidence and not on anything else.
I'm always kicked off. I'm always initially put, and then I'm
I can tell you why. It has to do with your responses when you're asked questions.
sure.
And if you want to be on a jury, I can tell you the things that you should say. You should always say truthful things, but don't volunteer things.
I don't volunteer. I never
Well,
have.
I'd have to be there to be
Yeah.
sure.
Yeah. I've heard that before. I mean, I've just answered, but
I know.
People can see into your soul.
I've never.
Doug, Doug, given,
Maya's speaking.
given,
She can see.
what goes on in society today with so many, people of color in jails and they're not getting as quality education as white people, and they have trouble, with the employment, various discriminations. Would you go so far as to say that slavery still exists today, or at least the types of actions towards colored people results in the same effects as slavery had?
There are places in our country where I would say that slavery exists while you're incarcerated. I would say that when you're on chain gangs in Arizona and you've got a sheriff out there who's going to make you work in 100-degree heat and work 10-hour days, that's about as close to, conditions of slavery as I can imagine. I wouldn't use that. I wouldn't give the sweeping statement, but I would say that involuntary servitude, you have prison labor, you have contracts that employers and companies do with prisons where they don't get free, but they get minimal wage, and they have sure, they can say no, but if they ever want to get out of prison, they take those opportunities. So when they appear before the parole board, they can say, well, I worked for this company for 3 years, and that helps them for that. So I always think that we're living in different forms of slavery and involuntary servitude. It's not going to compare, exactly with the image of during slavery. In that sense, things have improved. But there are times when the jailers who are holding you prisoners are going to act the same way as the overseers did when they were managing the plantation. They have absolute power over you. So it's the idea that it would be a overstatement to make it like it's the same thing as slavery, but it's almost like the modern day forms, the modern day vestiges of the institution of slavery. Call them cousins, call them relatives, but they have many of the same ingredients.
The 13th Amendment does allow for something like that.
The 13th? Yeah.
It does.
It does.
Yeah.
Yeah, it says except for as a punishment. So the language is in there. You can still, that's why you can have convict labor. You can have involuntary servitude as part of your sentence, as part of your punishment.
So if anybody's interested, Doug did a lot of study around the 13th Amendment and has a beautiful scholarly article that took me a long time to get through, but I learned a lot about the importance of the 13th Amendment. That was a good question.
Yeah. And there was, I thought, an excellent movie, Steven Spielberg's Lincoln,
That
talked about how the 13th Amendment got passed.
Lincoln was the other movie besides Glory.
Yeah.
And that's not even getting into Ava DuVernay's work. And she's done, she did a whole thing on the 13th.
Yeah.
So the 13th, I'm always finding ways. People still talk about equal protection, under the 14th Amendment. The 14th Amendment has been so diluted that it really, to prove any type of intentional discrimination, you literally have to have a smoking gun. You have to have the document or the person saying, I am discriminating because you're Black. And no one says that. Very rare.
But there's been a lot of steering in Baltimore where people, because we had clients in that business, and they would not show certain apartments to Black people.
Of course.
Well, that's steering, obviously. So,
But I
hard ways
in course, I don't think they'd ever do it. So, they did this interesting experiment with a couple of, orchestras where, you know, coming in to try to get on the orchestra, they would have a curtain, and they also had carpet, so you couldn't hear if somebody was wearing heels, and you couldn't see them. So you would only hear them.
Mhm.
And the orchestras that did that
Mhm.
became very diverse, both in terms of women and people of
Right,
color,
right, interesting.
much faster,
Yeah, yeah.
right? Right? And it just struck me, I mean, because we know
Yeah.
what happens in courts,
Yeah.
right? I mean, what would happen if the judge and the jury couldn't see the person, right?
Yeah.
And so they couldn't make that kind of judgment in terms of color and, right?
Ricky, there have been so many studies done for people who are prospective jurors. They're in what's called a jury veneer, so
Right?
those 50 or 60 people will be sent to a courtroom. And they did a whole study that even before the prospective jurors heard anything about the case, anything about the charge,
Right?
85% of them voted guilty from the mere fact that there was a trial and that there was a defendant. And everything about waiting until you get the evidence and.
Right,
and
right, yeah,
So people are primed to believe that when police make an arrest, they got the right guy.
right,
When
right.
when a prosecutor prosecutes the case, they got the right evidence.
So Doug, I remember talking to some of my colleagues at work. They said, I'm not sitting on a jury because they're already guilty.
Yeah.
Exactly what
Yeah.
you're saying. And this is real.
Yeah, I served on 2 juries. But one when I was 25. It was a drug case where the guy ran away from a location where the police were gathering to find people who were using drugs buying drugs out of the back of a truck. And he ran away, and they brought him to trial because the bar that he ran into had some marijuana, a stash of marijuana in a bag hidden in the wall. And they claimed that he had hidden it there.
Mhm.
Anyways, we went into the jury room. The forewoman, who was Black, we sat down and she said, okay, let's vote. I say he's guilty. That's the first words and I'm like, I'm the one who said, no, wait a minute. I think we need to discuss this, because if we were on trial, we would want people to think about our case first.
It's so good that you were there, Myra. I mean, really, this is why when my friends tell me I don't want to go to a jury, I don't have time. You know, you'll never get my blessing for that. It'll be like you have to try to get on a jury so you can do justice. Not that you're gonna say not guilty or anything like, just so you make sure that the government is doing a fair job of this, and that the person, the accused, is getting a fair trial. So please, if you have friends who are begging off for whatever reason, try to convince them at least to go through the process of, they may get bumped like Ricky does, you know.
I've gotten bumped twice.
You got bumped, but there's a lot of good people who often will say too much.
I was coached by the best and I still got bumped twice.
I'm convinced that when they find out that I'm a rabbi, that they want me.
Yeah, I'm sure they do.
Yeah, I think that helps you. So thank you so much for this. I would love to do this in a bigger, you know, place, because I really would like to speak to more white folks, without making it sound like I'm, you know, being condescending or anything.
I wonder if we couldn't do one of these sponsored by JUFJ that included all of the JUFJ congregations.
Yes, something like that. I mean, I'm actually gonna put a plug. I haven't done this before, but I'm actually gonna ask the public library if they have any openings for
It'd be
something like
great for the
this.
speaker
Yep.
series.
And that's one of the reasons I wanted to do this. I wanted to try out different things. 'cause-
Anything you ever want to try out, you can try out with us.
Well, thank you. Thank you so much for coming.